Hey everybody, welcome to another episode of Foreclosure Help 777, where we talk about everything foreclosure related. And as you can see, guys, this is my YouTube channel, but I have a Facebook page as well, where you can look at the cases we're going to talk about today. And these are some wins, foreclosure wins for the homeowner from New York. So let's get started. Okay guys, also thank you for subscribing if you have subscribed to my channel. Okay, so today's topic is recent New York foreclosure wins for the homeowner, a 2026 update. And the Bible verse of the day is going to be Proverbs 21:15, which says, "When justice is done, it brings joy to the righteous, but terror to the evildoers." Okay, so let's look at these cases. Okay, so today's presentation, we will examine several recent New York foreclosure decisions in which the homeowners prevailed against banks and mortgage servicers. These cases, decided primarily by the New York Appellate Division, 2nd Department, reinforce an important principle. Banks must follow the law just like everyone else. We'll discuss decisions involving standing, business records, RPAPL 1304 notices, contractual conditions, precedent, statute of limitations, the Foreclosure Abuse Prevention Act, or FAPA, and other critical issues that can determine the outcome of a foreclosure case. Each case offers valuable lessons about the importance of evidence, procedural compliance, and protecting homeowners' legal rights. Proverbs 21:15 reminds us, when justice is done, it does bring joy to the righteous, but terror to the evildoers. These decisions demonstrate that when courts faithfully apply the law, justice prevails, not because one side is favored, but because each party or every party is held to the same legal standards. Whether you're a homeowner, advocate, or legal professional, these recent cases provide practical insight into the evolving landscape of New York foreclosure law and the protections available to homeowners who know and assert their rights. The first case is Deutsche Bank National Trust Company versus Dennis, and this was decided March 25th, 2020. What happened? Well, the bank filed a foreclosure in 2010. The homeowner answered and asserted several affirmative defenses: lack of standing, failure to comply with RPAPL 1304, failure to send contractual default notice as required by paragraph 22 of the mortgage. The trial court initially denied the bank's motion for summary judgment because the bank failed to establish standing. Later, the bank asked the court to reconsider or renew, and the trial court granted summary judgment. The 2nd Department reversed, holding that the bank still failed to prove its case. My teaching point number 1, RPAPL 1304 requires proof of mailing, not just a copy of the notice. This is probably the strongest part of the opinion. The bank produced a copy of the 90-day notice, an affidavit from a loan analyst, a letter showing a certified mail number, but it did not produce the USPS certified mail receipts, proof of first-class mailing, an affidavit from someone with personal knowledge of the mailing practices. The court said it wasn't enough. The witnesses also admitted he did not personally mail the notice and wasn't familiar with the mailing procedures of the entity that was supposedly mailed it. The presentation takeaway here: a copy of a 90-day notice does not prove it was mailed. The bank must prove compliance with RPAPL 1304 through admissible evidence. This is one of the most cited principles in New York foreclosure litigation. My teaching point number 2 here, paragraph 22 default notice. Most mortgages require a notice of default before acceleration. The court held that the bank also failed to prove this notice was properly mailed because it relied on the same defective affidavit and lack of proof of mailing. So the presentation takeaway: many homeowners focus only on RPAPL 1304, but don't forget to examine whether the lender provided compliance with the mortgage's own notice provisions. My teaching point number 3, standing requires admissible business records. The banks claimed it had possessed the original note years before filing. Its evidence consisted mainly of an affidavit from a vice president who stated that, according to business records, the bank received the note in 2006. The problem: the witness never laid the proper CPLR 4518 business record foundation. The court explained, Unidentified business records aren't enough. Hearsay isn't enough. The records themselves must support the testimony. And an undated blank endorsement doesn't prove when the note was delivered. This is an excellent teaching example of why courts scrutinize business record affidavits rather than accepting conclusory statements. Another important lesson: even though the bank failed to prove standing, RPAPL 1304 compliance, and paragraph 22 compliance, the homeowner did not receive dismissal. Why? Because the homeowner's own motion for summary judgment also failed. The appellate court explained that simply pointing out weaknesses in the bank's proof does not establish as a matter of law that the bank lacked standing or failed to satisfy the required conditions precedent. The homeowner needed affirmative evidence supporting those defenses. This is a valuable practical lesson. Defeating the bank's motion for summary judgment does not automatically entitle the homeowner to summary judgment. The next case is Deutsche Bank National Trust Company versus EZEJI. Okay, the facts. The bank sought summary judgment claiming it possessed the original note before filing the foreclosure. It complied with RPAPL 1304 by mailing the required 90-day notices. Like many foreclosure cases, those facts were established only through an employee affidavit. The Second Department found that wasn't enough. Lesson number 1. The business records, not the affidavit, are the evidence. The bank's vice president stated, "According to our business records, we possess the note." The court responded, in effect, "Where are the business records?" The witness may authenticate business records, but the records themselves must be introduced into evidence. Without them, the affidavit is merely hearsay. Teaching point: the affidavit cannot substitute for the underlying business records. This is one of the biggest mistakes foreclosure plaintiffs make. Lesson 2. Standing requires evidence, not conclusions. The court reaffirmed that to establish standing through possession of the note, the plaintiff must prove it possessed the note and the endorsed note before the foreclosure was filed. Saying it possessed the note is not proof. The records showing receipt or possession must actually be before the court. Business records prove standing, not unsupported testimony. Lesson 3. RPAPL 1304 requires proof of mailing. The court again outlined the accepted methods of proving compliance. A plaintiff can establish mailing by USPS evidence, certified mail receipt, domestic return receipt, or postal documentation, standard mailing procedure, an affidavit from someone familiar with the lender's established mail office procedures, and personal knowledge, an affidavit from the individual who actually mailed the notices. What happened here? The lender produced an affidavit, a certified mail article number, but no evidence of first-class mailing, no USPS documentation, and no admissible proof from an office mailing procedure, and that was insufficient. Why this case is important? EZEJI reinforces the current theme of New York foreclosure law. The court requires evidence, not assumptions. The plaintiff cannot simply state, "We have the note, we nailed the notice." The plaintiff must produce admissible evidence supporting these assertions. The next case, U.S. Bank N.A. versus Ingber. Decided March 16, 2026. Why this case is important. Most foreclosure presentations focus on standing, RPAPL 1304, or paragraph 22 notices. Very few explain that the bank has to also prove the amount it claims it's owed. Judge Morozink spends much of this opinion explaining this point. Lesson 1. A referee's report is not automatically accepted. The court stated that a referee's findings are only advisory. The judge must independently determine whether the report is supported by admissible evidence. If it isn't, the report must be rejected. So the takeaway is this. A referee does not decide the case. The evidence still has to satisfy the rules of evidence. Lesson 2. The plaintiff must prove damages like any other civil litigant. This is one of my favorite passages. The judge wrote that a foreclosure plaintiff bears the same burden as every civil plaintiff. It must prove that the amount due with admissible evidence, The court emphasized that computing the amount owed is essentially an inquest on damages, and the plaintiff bears the burden of establishing that amount. This is a concept many homeowners have never heard. Lesson 3. Even a defaulting homeowner may challenge damages. The borrower has defaulted years earlier. The bank argued that because of the default, the borrower couldn't challenge the amount due. The court rejected that argument. A default admits liability allegations but does not establish damages. The borrower still has the right to contest what the bank claims is owed, and that is a powerful teaching point. Lesson 4. Power of attorney must actually confer authority. This is something that is often overlooked. The banks relied on a chain of a power of attorney, U.S. Bank to New Res to PHH. But those powers depended on servicing agreements that the bank never produced. Without those agreements, the court held that the bank failed to establish that the affiant had authority to act for the plaintiff. This is a valuable lesson for examining servicing relationships and agency authority. Lesson 5. Business record foundations must be specific. The opinion is almost a tutorial on CPLR 4518. The judge explained that the proponent must establish the records were made in regular course of business. It was the regular practice to make them, and they were created at or near the time of the events, and that they are trustworthy. Then the court explained why the affiant failed. She merely stated that she was familiar with the records, but she never stated she had personal knowledge of the record-keeping practices, and that was insufficient. Lesson 6. General statements don't authenticate every document. This is probably the strongest evidentiary discussion in the opinion. The judge held that it had not enough to describe general business practices. The witnesses lay a foundation for each specific exhibit. Blanket statements do not authenticate every attached document. This is a fantastic point to teach because so many foreclosure affidavits rely on broad conclusory language. Lesson 7. Electronic records require authentication too. The court further held that the affiant failed to establish that the electronic records were true and accurate copies, and that the information came from someone under the business duty to accurately record them. Without those foundational requirements, the business records remain inadmissible hearsay. Lesson 8. The court rejected the referee's report because the plaintiff failed to establish admissible evidence supporting the amount due. The referee's report was rejected. That demonstrates an important point. If the evidence isn't admissible, the calculations based on it are not admissible either. Okay, guys, that does it for today's episode. These winning cases, you can certainly find them on my Facebook page. I have the opinions already there. And thank you to Phyllis Ferrero for posting those for everyone to read. And as always, a win for one is a win for all. And as always, everyone have a blessed day.